Hi guys, welcome back to the Shackles of Debt, where we talk about financial literacy, money tips, and debt freedom. Today I want to talk to you about bankruptcy and everything you should know about going bankrupt. I'm going to specifically be talking about bankruptcy in the United Kingdom, in the UK. So that's England and Wales mainly. And bankruptcy laws might apply differently wherever you're living in your part of the world. So I'd always suggest doing your research before doing anything. Don't forget to like, share, comment, and subscribe. It helps other people to discover the video. Bankruptcy is a legal process that can be undertaken when a person has failed to pay their debts. The process allows a person to pay back some of the debt that's been owed and to write off some of them. In order to be eligible for bankruptcy in the UK, you need to owe a minimum of £5,000. Now, filing for bankruptcy is a very difficult decision to do. It's a devastating choice to have to make, and it's pretty extreme. So before even considering bankruptcy, have a look and see if there are any other ways that you can pay off your debts before you file for bankruptcy. And before you even decide to file for bankruptcy, you should make sure that you get some free impartial debt advice from a debt charity like Step Change or Pay Plan before making this decision. There are several consequences of filing for bankruptcy in England and Wales. The first one is that filing for bankruptcy results in your name being placed on an insolvency register. This register contains the names of people who've been made insolvent through bankruptcy, debt relief orders, and individual voluntary agreements. And your name remains on this register until 3 months after your bankruptcy has been discharged. There are several rules you have to follow when you do become bankrupt, and failing to abide by these rules can result in criminal action and prosecution. So these rules are, number one, you can't act as the director of a company without the court's permission. You can't create, manage, or promote a company without permission from the court. You can't borrow more than £500 from anyone without disclosing the fact that you have been made bankrupt. You also can't continue running a business without telling your business partners that you've been made bankrupt. You can't work as a debt insolvency practitioner, although I don't know why anyone would want to do that anyway if they are bankrupt. But yeah, that's one of the rules. You can't work as an insolvency practitioner. And the bankruptcy remains on your credit file for 6 years. It adversely affects your credit. But after the 6-year period is finished, it is erased from your credit file. Now, not all debts can be written off by bankruptcy or included within the bankruptcy filing. These debts are student loans, TV license fees, debts that are obtained through fraud, child maintenance fees, criminal fines, or court-ordered fees in divorce filings. So if you think that this is a way to easily get all of your debts written off, no, because not everything is included. So carefully analyze what debts you owe before making this decision. However, debts such as overdrafts, store cards, loans, utility arrears, rent arrears, they can all be included in the bankruptcy filing. Also, debt from goods that have been obtained through finance, such as cars, sofas, fridges, etc., that are all on finance, can be included in the bankruptcy filing. But more often than not, by the time it gets to that, the creditor may have already repossessed the particular item anyway, but the debt can be included in that. And like I said, rent arrears can be included in the bankruptcy filing, but by the time it gets to that point, your landlord would have probably evicted you anyway, and they are allowed to evict you. A mortgage can be included in a bankruptcy filing, but only if you've surrendered the property or the property is repossessed. There are 2 ways in which bankruptcy can happen. So you can either make yourself bankrupt or a creditor can make you bankrupt. Here is how a creditor can make you bankrupt. They can do this after other debt collection processes have failed. So if they have sent bailiffs over, if they've got a county court judgment, if they've made numerous attempts in order to get their money back, they can actually make you bankrupt themselves. And what the creditor normally does in this situation is that they apply for something called a statutory demand. And a statutory demand is a notice that gets sent to you, and it is basically a warning that bankruptcy action is pending. And it's also a formal request for you to pay back the debt that is owed. And you have 21 days to respond to this statutory demand and either pay the debt in full or to arrange a payment plan with the creditor. And if you don't respond within the 21-day period, then the creditor can go ahead and start taking bankruptcy action against you. Here's how to make yourself bankrupt. So if you decide that bankruptcy is the course of action that you want to take and it's the route that you want to go down, here's what you need to do. Number one, you need to go on the government website and complete something called a petition for bankruptcy. You need to pay the fees. In England and Wales, it's actually quite expensive to become bankrupt, which is quite ironic because if you're in a place where you don't have enough money to even pay back your debts, they still expect you to pay this fee. So it actually costs £680 to make yourself bankrupt in England and Wales. £130 is for the application fee and £550 is the bankruptcy deposit. Once you've submitted your application, once you've paid the fee, it then goes to someone called an official receiver. So an official receiver is a person who will be allocated to your case. And if your bankruptcy application is approved, then the official receiver will officially take control of all of your assets. And what they will do is they will arrange for your assets to be sold. But things like your essential household items, so things like cookers, fridges, they won't be sold because you need those items in order to survive. You may also have to make payments towards the bankruptcy for up to 3 years. And that is called an income payment arrangement. An income payment arrangement is agreed upon if you have disposable income of more than £20 a month. So what happens after the bankruptcy? You'll be released from bankruptcy after 1 year. That's normally the length of time that the bankruptcy lasts. And this means that the debts that were part of the bankruptcy are now written off, meaning that they're now gone, but you will still need to continue on paying for the debts that weren't included in the bankruptcy. And if you were placed on an income payment arrangement, an IPA, then you still need to continue making payments for the 3-year period. All of the assets that were seized in the bankruptcy, you might not be able to get those back, unfortunately, even if they haven't sold yet. But you can speak to your insolvency practitioner and see what can be done about this. If you manage to acquire any assets after the bankruptcy has been filed, so let's say you manage to buy a house after the bankruptcy has been filed, that can't be included in the bankruptcy and you're allowed to still keep that because it's now yours and it wasn't part of the original filing. So choosing bankruptcy is not an easy route to go down, and it's not a decision that should be made lightly, and it can have some devastating consequences. But even though it has a lot of consequences, it can be a fresh start for someone, and it's a way to write off debt that you're not able to pay back. Have you ever experienced bankruptcy? Have you considered it, or are you in the process of considering going bankrupt at the moment? Let me know in the comment section below. And again, don't forget to like, share, comment, and subscribe. And I will meet you in the next video. Thank you.